Hello and welcome back. This is the lecture video for assignment number 32. And in this video, we're going to talk a little bit about two different types of due process. And we are then going to take a quick little look at one of these two types, procedural due process. At the end of the last video, we talked about how the Supreme Court's incorporation of the Bill of Rights to apply to the states through the Due Process Clause of the 14th Amendment had brought new importance to the concept of protections for due process. But what does due process mean? It can mean a number of different things, and there are different ways to look at it. At a minimum, it means that the government can't take away anyone's life, liberty, or property arbitrarily. But what exactly that all entails is something that there has been big disagreement about and has caused a lot of controversy on the Supreme Court. There are two primary ways that people think about the concept of due process. The first concept of due process is procedural due process. So procedural due process tells us that the government has to follow certain procedures before it can take away our life, liberty, or property. So this is a way for us to be protected from having our life, liberty, or property taken away from us arbitrarily. It won't be arbitrarily. We won't have the government just show up one day and take away our property. Rather, they have steps that they have to go through before they can do that. And due process can mean a lot of different things. Procedural due process can mean a number of different things, as we'll talk about a bit later in this video. But at a minimum, we have been told by the court that our rights to procedural due process means that we will have notice that the government is going to take some action and a right to be heard that is appropriate to whatever the situation is involving the right. While there can certainly be disagreements about the details surrounding procedural due process, the concept itself is not controversial, that the Constitution's due process clauses protect us from having our rights deprived without certain kinds of procedures having to be followed. But the other concept of due process is known as substantive due process. And this view of due process definitely has engendered controversy. So with substantive due process, we are talking about the adequacy of the government's reason for taking away someone's life, liberty, or property. So substantive due process is the concept that through the due process clauses of the Constitution, we all have safeguards against the government depriving us of life, liberty, or property arbitrarily, as we talked about with procedural due process. But in this case, the arbitrariness is to their reasons. We have protections that they will not do this for arbitrary or capricious reasons. There is also sort of a companion concept of substantive due process, which is that substantive due process refers to the Supreme Court's recognition of certain liberties being protected by the due process clauses as fundamental rights. And this is a concept that evolved through the debate over incorporating the Bill of Rights to apply to the states that we talked about in the last video, where the court said that there are these certain rights that are so fundamental that it would be a violation of due process for the government not to honor them or for them not to be protected. Not only does the recognition of fundamental rights being part of the due process clause mean that they are going to be applied to the states, but under substantive due process, the court has also said that the standard of review for rights that are deemed to be fundamental is higher than it would be for other types of rights. So through substantive due process, the government needs to have a more compelling justification before it can deprive someone of a fundamental right. You'll often hear people talk about the concept of substantive due process who are really focusing on this practice of the court identifying certain rights as fundamental rights and then placing a higher burden on the government in order to have some regulation that affects them. But the overall concept of substantive due process can also refer to a burden that is placed, a lower burden that might be placed on the government for the denial of all kinds of potential rights or liberties, even those that are not deemed to be fundamental. We'll talk some more about substantive due process, and in fact, after we get through a brief discussion of procedural due process, the rest of our semester is going to be thinking about substantive due process, because I know it might not be 100% clear right at this moment, but I just wanted to start by giving you sort of a basic idea of the two different types of due process that we are going to be talking about. At a basic level, you can understand the difference as procedural due process would require the government to provide things like notice in a hearing before they could terminate someone's custody of their children. The procedures have to be followed. Substantive due process would require that the government provide, in that case, a compelling reason, because the care and custody of your children is deemed to be a fundamental right, a compelling reason before they could terminate custody. So substantive due process would be focused on the government's reason or justification for the deprivation of liberties. But let's take a few minutes right now to talk about procedural due process, which is, again, the idea that the government has to go through certain procedures before they can take away your life, liberty, or property. That due process is a protection against these rights being deprived arbitrarily. And we protect procedural due process. Procedural due process is very important because it accomplishes a number of important things. Through procedural due process, we get more accurate results. We aren't going to, or we're less likely to wrongly put someone in prison because we have gone through the procedures that we give to criminal defendants. We're less likely to take away someone's property or to deny him or her an important right, like having a driver's license or having the custody of their children. Because, again, we had procedures, we had a hearing, we had an opportunity, they had an opportunity to tell sort of their side of the story. And procedural due process furthers this chance to tell your side of the story as a value in and of itself, a recognition that there is simply, we all simply have an interest to be heard by the government, even if we do ultimately end up being deprived of the property or liberty interest. Due process is also a restriction on the government. It forces the government to follow laws. By going through the process, we have an opportunity to hold power to account and to make them follow the letter of the law. So in a lot of ways, procedural due process can be the closest thing we have to a kind of constitutional promise of fairness. At a minimum, you will be told what is going to happen or what and why. You will have a chance to be heard. Often you will have a chance to appeal or to present evidence, different types of procedures that bring about a form of fairness. There are a few key questions that come up when we're talking about procedural due process. We need to know what we are talking about when we have protection for life, liberty, or property. We need to know if there actually has been a deprivation of someone's life, liberty, or property. And if those two things are present, we do have life, liberty, property, and there has been a deprivation, then we get to the question of, well, then in this case, what kind of process is the person due? I only had you read a case relating to the third of these questions, but the other two do need to be answered before we get to the question of the third. So when it comes to the question of what kind of process is due, the Supreme Court, as I've mentioned, has told us that at a minimum, before your life, liberty, or property can be deprived, there needs to be notice and an opportunity to be heard. But this leaves all sorts of questions that we might not know about what those procedures might look like. What kind of notice? Do you have to be personally served? Is it okay to post something in a newspaper to give people notice? What about what kind of hearing to be heard? Do you get the full protections of a full trial? Do you even get the protections of an adversarial hearing where you get to sort of have your own representation to make your argument and produce evidence? Do you have a right to a lawyer? There can be questions, of course, about who has the burden of proof, who is the final decision maker in these cases. So we have a lot of questions about what exactly this kind of process needs to entail. And the key case on this question is the Mathews versus Eldridge case from 1976. This case involved a man who had been receiving Social Security disability benefits for about 4 years. And he gets a notice that his benefits have ceased. And he challenges the procedures that occurred in this case. So in this case, he received a questionnaire asking for some information about his condition, about whether his condition had not improved, about identifying some medical sources, doctors, etc., from whom he had received treatment. There were reports from his doctor and a psychiatric consultant. Then he received a letter saying that they had made a tentative determination that he was going to stop receiving these benefits. But he had the ability to request some time to obtain and submit additional information about his condition, and he filed a written response. And after that, the state agency made a final determination, and the Social Security Administration accepted it. So they were then notified, and he had 6 months to seek reconsideration of this decision. So first we have the question about whether or not we had life, liberty, or property for a procedural due process issue. The court says, yes, we have property here. It's a statutorily created property interest in being able to receive these benefits. Also a question of whether or not there's actually been a deprivation of his property. Again, the answer is yes. He used to get Social Security benefits, and then the government deliberately took them away. So what Mr. Eldridge wants here is more process, or a different kinds of process than what he received. He wants an evidentiary hearing before there was this initial deprivation of benefits, and then he wants continued benefits until a final determination of ineligibility is made. So the Supreme Court in Mathews v. Eldridge gives us a 3-part balancing test for considering procedural due process claims. First, we consider the private interest involved, the importance of the interest to the individual. Then we consider the risk that we might have an erroneous deprivation of this interest and the value that might be added from having additional procedures, the value that additional procedures would give us in having an accurate deprivation or accurate fact-finding leading to the decision in this case. And then we also weigh the government's interests. So the cost to the government for having additional layers of procedure. So when we think about these 3 interests and how the court is balancing them, we see how we have this private individual interest, the private interest, and that, of course, the more important the interest is to the individual, the more procedures that we are going to require. So here Mr. Eldridge is arguing in favor of getting uninterrupted receipt of this income until there is the final administrative decision on his claim. And he relies on a prior Supreme Court case, the Goldberg case, where the court said that due process requires an evidentiary hearing before there is a temporary deprivation of benefits. The court, however, doesn't buy this argument here. They say that the Goldberg case involved welfare benefits. This case involves disability benefits. So they said the welfare benefits are given to people who are on the margin of subsistence, in their words. And that is not necessarily the case with disability benefits. People who receive disability benefits they aren't need-based, so they could still have access to other private and public resources. When we get a chance to talk in person, I'll definitely want to ask you your opinion on that argument, whether you think that makes sense or not. The court then considers the second factor, the risk of an erroneous deprivation and the value of additional procedures. So we don't, of course, want to have just procedures for procedures' sake. There has to be some, point at which we are going to place a limitation on what procedures can be received. And the court in this case concluded that the procedures here were fair and reliable. Once again, they compared them to welfare benefits. They said the disability test was very straightforward. There was documentary evidence. Unlike, they said, welfare evidence, which can be more complicated. There can be issues of witness credibility, he had full access to all information that was relied upon and was given a specific reason for denial that he was able to respond to. And then finally, the court considered, we have the third element, which is the government's interests. So there are costs to the government from every increase in the number of hearings and the expense of providing benefits to ineligible recipients as we are pending the decision that the court found persuasive. Acknowledging that at some point each additional safeguard to the individual is going to be outweighed by its cost to society. So again, when we meet, I'll be interested in hearing what you think about this test, whether the Mathews v. Eldridge test strikes a good balance between the costs and benefits of procedure, or whether it raises other issues that you might find concerning. And that's all I had for you today about procedural due process. I look forward to seeing you all on Monday. Bye.